was.
Thank you.
All right, thank you.
Thank you, counsel. The next case is Anderson versus State.
Good morning, Your Honors. May it please the Court, I'm Michael B. Jones from the Wheelock Law Firm of Orlando, Florida. We have the privilege and honor of representing the appellant here today, Mr. Joseph Anderson. If I may begin, reserve about 3 minutes for rebuttal. Okay. I would appreciate it, Your Honor. We have detailed in our brief
if this happened in New York City and you know, the evidence was it was right in front of the Empire State Building, that's enough to prove venue, right?
Absolutely, Judge Thorpe, and I'm very glad you used that analogy.
The BMX park, a familiar enough place down there, and where was this, Kissimmee?
I believe the event occurred allegedly in St. Cloud, but in Osceola County, yes.
Right. Is the BMX park, close enough, familiar enough to everybody that, that makes a case for venue, right?
I think that's absolutely correct, Your Honor, and I think that when you're dealing with a county and a thing like a BMX park, which is ubiquitous, it's not described in any way. That would be like saying it happened at the McDonald's and there's 30 of them with...
Well, I mean, the trial judge is probably in a better position to know that than we are, right? We're not from St. Cloud, so...
I think that may be true, Your Honor, but I don't think that makes the decision. The burden is on the state to prove every element, every essential element of a case beyond and to the exclusion of a reasonable doubt. One of the elements of every crime is that it occurred in the venue that it is being tried in. If there was a specific reference to a place, and I was actually going to use the Empire State Building as my example, but if we stated that something occurred at the 5th District Court of Appeal Courthouse, there is only one of those buildings. We know it's in Daytona. We know it's in Volusia County. But if we describe that something occurs in a McDonald's, that would not be a sufficient allegation, just like a BMX. If it had been more specific, Mr. Green's BMX bike park, the BMX park at the corner of Elm and Main Street, all of those would have been more descriptive and would have described one particular place. Obviously, of course, the proper question is, was that, in St. Cloud, Florida, and in Osceola County? Yes, and then you've proven it. The state failed to prove venue in this case, and I think that is fatal, and the court should...
If the trial judge finds that something is prominent enough or it's a landmark such that he knows where it is, what does he have to do? I mean, what kind of record does he have to create for us to review? Do we just have to defer to him, or does he have to somehow explain why he's treated something as a landmark or well-known?
I think he would.
Because he did say in this case, we know, in essence, we know where it is, right?
Well, I'm not sure he did say it that distinctly, Judge Palmer. I think that it was a situation in which he said, well, yeah, okay, and just we know where it is. And I don't think that is descriptive enough, and I don't think it's enough of a record, and I'm not really pinning it on the trial judge. I'm really pinning it more on the state for failing to prove an essential element of the case. I just don't think that, I think that if the trial judge has said, yes, there's only one BMX bike park and we know it's on Elm Street, that might have been enough to establish it, but I don't think it's the trial judge's duty to correct or fill in the state's case, or for that matter, the defense's case.
Well, but the trial judge did deprive the government of the opportunity to reopen the case by making the ruling that he or she did, right? In other words, if he just said, well, he didn't prove venue, couldn't the government have asked to reopen the case to prove venue at that point?
The court could have, the state, yes, absolutely could have asked for that, and still could have asked for that to preserve their record and to show that they had, in fact, done that essential element of the case.
How about moving on to the photograph of the knuckles issue?
Yes, sir.
Yeah.
I think that's a very important situation. That is a Brady violation, as set forth in our initial brief and in our reply brief as well. The situation is that if you have evidence immediately after an event that supposedly caused permanent disfigurement, grave injury, or the other standards or criterion that would be necessary to establish an aggravated battery. And there's evidence that the alleged weapon, the fist, is unmarked. I think that's very relevant and potentially exculpatory evidence. When the state withheld that, I think they were improper in doing so.
Do we know what the photo showed?
I believe there's record evidence that in the discussion that it showed that there was no marks on the knuckles.
I didn't hear you, Mr. Jones, that there was what? There were
No marks on the knuckles. The hands did not look like...
Now, this is the photograph that the prosecutor downloaded off of the Facebook page or MySpace or something?
No, sir. There are two different photographs involved here. One is the photograph that was taken by police officers immediately after the incident.
But that came into evidence, right?
That's the Brady violation.
Okay.
There was a failure to disclose, Your Honor, and that was a Brady violation.
And did that come into evidence, or was there even proof that it existed?
There was proof that it existed. It was discussed. The police officer said he took pictures, but the pictures were not given to the defense. That's the point.
And they weren't put into evidence?
Excuse me?
They were not put into evidence?
I do not believe they were. I can check the record while the state is making their presentation. What you're referring to, Judge Dorpy, is the second photograph, which was supposedly on a social network we've broken it down into three subparts of prosecutorial misconduct, but it is related. Basically, the picture before it was in evidence was published or flashed or presented to the jury.
We don't really know that, right? I mean, from the record, whether or not the jury saw that photograph.
There was absolutely no voir dire of the jury to say, Mr. Smith, did you see the photograph? Mrs. Green, did you see the photograph? That's correct. However, when the jury was in deliberation, the jury came back with a question, we want to see the photograph. So I think there is certainly an inference that if they didn't see it fully, they knew it existed, it was presented in such a way that they could have seen it.
Was there discussion of the photo in the presence of the jury?
Absolutely, because it was put up in...
So they could have asked to see the photo even if they had never seen the photo, right?
That's correct,
but
they could have asked that. That is correct, Your Honor.
But the judge excluded the photo based upon the
Richardson violation.
Richardson
yes,
violation. Right?
Absolutely.
Right.
And but there is compounded in that situation was the prosecutor personally was doing the investigation, potentially becoming a witness of it, and there was no tying or showing that from the social network that this particular photograph was in fact from or under the control of the defendant. As I understand Facebook, you can tag your friends on a picture and then it shows up on their page, so you have a certain lack of control of pictures even that have your name tagged on them, so there would not be that kind of showing. And our position with regard to prosecutorial misconduct, and we've set out 5 subpoints of them, is that any one of them alone would be sufficient, but all of them together certainly would be sufficient, especially when you add in the improper comments questioning whether a person spoke with their own lawyer, making the very improper inference that it was somehow improper for defense counsel to talk to witnesses. We're absolutely entitled to talk to witnesses. There was the statements about, well, he was just prepping the witness. He prepped this witness. He prepped that
What was the
witness.
question that the state attorney asked appellant right before, he revealed that there was this photograph off the MySpace or Facebook?
I don't recall the exact question, Your Honor.
He was getting at whether or not he had damage to his hand, right? Is that?
That's correct.
And this was going to be, this photograph was going to be used to impeach his answer, right? That he had no damage to his hand. Is that how it played out?
I'm not sure I can speak for the prosecutor's mind because it was stopped at that point. I think that's a reasonable inference that it was an impeachment type of a situation. But when you bring in prejudicial evidence that you have, in fact, investigated and done with no showing that it was proper to the, could be tied to the appellant, it's entirely possible he had bloody hands from a car wreck 6 months before or after, and it would have been irrelevant. So the overall cumulative effect of the prosecution's situation was such. The last point I want to address just briefly, all 5 points are set out in great detail in our briefs, but is the situation of the charge of and failure to give a directed verdict against the felony battery. As charged and as instructed, it was erroneous. These are our points 2 and 5. There were specific acts charged to specific defendants. There was none of this general, they all did something and all should be mutually responsible, and that was error. And I think it is prejudicial because as the jury came back with a simple battery, we can make a reasonable inference that it was something of a compromise type of decision and that they should not have even had the option under these facts as presented of having a felony battery. Unless the court has any more questions, I'll just reserve the last 4 minutes or so if I need any rebuttal. Thank you.
Thank you, counsel.
May it please the court, my name is Chris Davenport and I represent the state of Florida. If I could start with this picture issue because I think this is getting a little confused. The defendant got up and testified.
I'm more interested in the one about the one that the prosecutor went and downloaded during the break.
Okay. So
how'd that play out in the courtroom? He was cross-examining the appellant, and what was the question that he asked and the answer right before we
got into this internet picture.
thing, yeah.
Well, what happened was the defendant testified that he didn't hit him. So on cross-examination, he said, he saw the fight, he walked away. So on cross-examination, the prosecutor said, do you have a Facebook or a MySpace page? The defendant said yes. The prosecutor says, I have an exhibit here, I want to get it marked. He was going to ask the defendant about this picture, which he had apparently downloaded after the defense counsel's opening statement, is what the prosecutor said. Did he say it was a photograph?
You say, let me show you this photograph?
He said, if I can approach the bench. They went up to the bench, and he said, I want to have this photograph marked. Defense counsel said, wait a minute, what photograph are we talking about here? That's when they had the Richardson hearing. The trial judge said, you had to have disclosed this before the defendant testified.
Isn't that dirty pool, though? I mean, don't you have to, isn't that the whole purpose of mandatory disclosure, that if you got some kind of physical evidence that you don't spring it on the defendant in the middle of the trial?
Well, sure, but first of all,
the defense lawyer's got to object, so the jury's going to possibly draw an inference that they got a smoking gun here, I mean, if he'd have had it in advance, then he could have filed a motion in limine
this was a picture that was on the defendant's Facebook page, apparently. We haven't seen the picture. It never got entered into evidence.
It's not even authenticated. I mean, the government can't authenticate that picture, right?
Sure they could. If they'd audited the defendant and they'd have said, is this a picture from your Facebook page? And he'd have said, yes, it is. I took that picture and posted it. That would authenticate it.
Maybe.
We never got that far.
Maybe if he'd have said it was an accurate depiction of my hand right after the fight, maybe they could have authenticated it. But by that time, the cat's all out of the bag. I mean,
Well, the defendant was the one who said they took let me back up a little bit because this gets into the Brady picture too. The prosecutor said, did anybody ever take a picture of your hand? He was asking about this Facebook thing. This apparently came up in opening statement. Now, the opening statements aren't transcribed. They didn't order that as part of the record. But the prosecutor said during the course of this conversation, I went and looked at this guy's Facebook page because of what he said in opening statement. I don't know what that was because it's not in the record. So the prosecutor's trying to get this picture in to show that he has a picture of apparently injuries to his hand. He starts asking him about pictures. That's when the defendant says, oh, the police took pictures of my hand and it actually showed no damage. Now, when they addressed this in the motion for a new trial afterwards, the prosecutor said the police didn't take pictures of his hands. He made that up. I didn't have an officer here to testify, so I didn't get into that with him because I couldn't dispute it. But there are no pictures. This Brady violation, there is absolutely no evidence that those pictures by the police ever existed. So what the prosecutor was talking about was the Facebook pictures or MySpace. And the defendant brought up this, yes, the police took pictures of my hand and it showed that there was no damage. So the defendant interjected this other issue of pictures that, from what we can tell so far, don't exist. So that's why they weren't disclosed, according to the prosecutors, because they were never taken. So then they started getting, the prosecutor wanted to talk about the Facebook pictures because that was apparently showed damage.
But doesn't the prosecutor have a continuing duty to disclose evidence to the defense, even if it's evidence that he came up with during the break?
Yes, when he
And the
downloaded those
appropriate thing to
pictures,
do-
he should have disclosed them to the defense, which is why they were excluded.
I know, but the appropriate thing to do would have been to disclose it before the jury's, outside the jury's presence, so that the defense lawyer would have had an opportunity to react to it, make objections outside the jury's presence, so that there's not this inference that the jury might draw, when he sets them up for the kill and goes in for the kill, and then the defense attorney is standing there flat-footed. It just doesn't seem fair to me. If they have a duty to disclose, the duty was when they walked into the courtroom after having downloaded the picture from the MySpace page, to walk over to defense counsel and say, hey, I just downloaded this and here it is, and I'm going to use it.
Absolutely, which is why the trial court said, you can't disclose this after the defendant has already testified.
But they sandbagged. They waited to do the disclosure to the right. They waited to do it until they got the defendant on the stand and got him in a precarious position, and then started flashing around a document. And, that's just really unfair for them to do that.
I agree that should have been disclosed as soon as he got it. But as far as how that impacted the fairness of the trial, it backfired on the state to the extent that there was some kind of malicious sandbagging going on here. I mean, it backfired because the defendant said, oh, yeah, the police took pictures and it showed no damage. And his buddy confirmed that. He testified, yeah, I was there and they took pictures.
Well, it is sandbagging. I don't know if it's malicious sandbagging
Right.
or the result of a lawyer that is a novice, but it's definitely sandbagging.
He definitely should have disclosed it, and as a result of that, the trial court wouldn't let him introduce this picture, which apparently showed damage to the hands. So that's what the deal is with the picture. There is no Brady violation
Do we have
here.
the picture?
We do
Did the
not.
picture ever make it into the record?
It did not make it into the record. The trial judge afterwards said, defense counsel asked to have it entered into the record, the internet picture. The prosecutor couldn't find it. The trial judge said, find it and put it in there, and if you can't find it, tell us why. And he told defense counsel, if he doesn't comply with this, file a motion and we'll deal with it. And that's the last we ever heard of it. It's not in the record. But, to the extent there was sandbagging here, it certainly didn't prejudice his right to a fair trial, because the only testimony the jury heard about a picture was the defendant and his friend who said, yeah, this picture showed no damage. So if anything, it hurt the state. Turning to the venue issue here, the trial judge is in the best position to determine what the deal is with this BMX park. It's not a McDonald's. There's not a million BMX parks in every city. When defense witnesses testified, they said, yeah, we went to the St. Cloud BMX park. There's no allegation here that the defendant's right to be tried in the proper county was violated. It's more of a technical, did the state ask the correct question? The trial judge said he did. The record does not support that ruling. If the trial judge had said, yeah, he didn't prove venue.
Mr. Jones said it was an element of the crime that the state must prove beyond a reasonable doubt.
That is not correct. Yeah, this court has specifically said it's not an essential element. There's a lesser burden of proof. And the remedy for being tried in the improper venue is a new trial in the proper venue. So this guy, what would his remedy be? Another trial in St. Cloud. It just doesn't make sense in this context where there's absolutely no question that he was in fact tried in the proper venue. If there are no other questions, we would ask the court to affirm. Thank you.
Thank you, counsel.
To answer the question I was asked on direct, I do not see a record evidence that either photograph was admitted, so I would say that they were not. I just did a quick check of the record. Unless there's any other questions, I will rely on my previous argument and on our brief and ask for the reversal. Thank you, Your Honors.
Thank you both. Well done. The next